The ballroom was full 70 people, maybe more. My son stood up during the toast and said it very clearly. The way you say something you've rehearsed 100 times. You're not family anymore. What he didn't know, standing there in front of everyone I had ever worked with or trusted, was that the $800,000 he owed me and everything attached to it had already been set in motion that morning. The room didn't go quiet. It got louder. People laughed. They thought it was a joke. What they didn't know was that I'd already made 3 calls that morning to my attorney, my accountant, and the title company. By the time he sat down, he had exactly 4 hours left before everything changed. I finished my drink and set the glass down. Then I called my attorney again. She answered on the second ring. She said, "Is it time?" I said, "It's time." The Heath man had hosted a lot of events over the years. I'd been to 3 of them in that same ballroom, a retirement dinner for a colleague in 2009, a charity auction my wife dragged me to in 2014, and now this, my 60th birthday. The room smelled like gardenias and warm bread. The lighting was the kind that makes everyone look 10 years younger, which I suppose was the point. Marcus had arranged everything. He'd insisted on it. He'd called me 3 weeks before and said, "Dad, let me handle this one," and something in the way he said it, too smooth, too certain, made me agree. I'd been watching my son arrange things for a long time. I knew what it looked like when he wanted something. He stood with a champagne flute in his hand, jacket pressed, hair combed back the way he'd worn it since he was 25. Jennifer sat beside him with her hand on his arm, smiling at the room the way you smile when you've already decided how the evening ends. Marcus spoke for about 90 seconds before he got to it. He thanked people for coming. He mentioned the hotel, the food, the occasion. And then he looked at me across the table, not the way a son looks at his father on his birthday, and he said it, clear and final, like a deed transfer. "You're not family anymore." I picked up my fork. The man to my left, Gerald Whitmore, an engineer I'd worked with for 11 years at Cascade Civil, leaned over and said, "Did he just—" and then stopped himself because the table behind us had already started laughing, and the laughter spread, and Marcus sat down looking satisfied, and Jennifer touched his hand. I finished the salmon. It was good salmon. I thought about the calls I'd made that morning, the first at 7:42, the second at 8:15, the third just after 9. Patricia had said, on that third call, "Everything is filed. We're ready when you are." I'd told her I'd let her know. I let her know at 10:47 that night, standing in the parking garage on the second level, my jacket folded over my arm. My phone showed 49 missed calls, all from Marcus. I didn't count them at the time. I found out later, when Patricia asked me to document everything, and I scrolled back through the log. 49 calls between 9:18 and 10:44, 26 minutes of silence, and then my phone rang one more time. I didn't answer that one either. I got in my car and drove home on Burnside the way I always did, past the construction site on 14th that Marcus's company had broken ground on 6 weeks ago. The cranes were dark. The whole block was quiet. I didn't stop. I had known Marcus's company was undercapitalized for longer than he realized. That is the thing about spending 34 years reading structural drawings and load calculations. You learn to see the places where the numbers don't hold. When Marcus first came to me 5 years ago, in the fall, he sat across from me at my kitchen table in the house on Thurman Street and spread out a set of project documents the way young men do when they want to appear prepared. He had printed everything on heavy paper. He had a folder with tabs. He explained the opportunity in careful, measured sentences, and I listened the way I had learned to listen on job sites, not to the words, but to the spaces between them. The project was a mixed-use development on the west side of downtown Portland, 11 stories, ground floor retail, residential above. The location was good. The concept was not unreasonable. Marcus was 31 years old and had been working in real estate development for 4 years. First as a project coordinator for a mid-size firm on the east side, then on his own for the last 18 months. He had one completed project to his name, a 6-unit residential conversion in Southeast that had taken 2 years longer than projected and come in 40% over budget. He did not mention the cost overruns. I knew about them because I had asked his former employer, a man named Gerald Cho, who had worked with Marcus for 2 years and whose opinion I trusted. I did not tell Marcus I had made that call. He needed $800,000 to close the land acquisition. He had secured a construction loan contingent on the equity contribution, and the equity gap was exactly that number. He presented it as a bridge short-term, 18 months, with a clear repayment structure tied to the project's construction draw schedule. He had a term sheet prepared. He slid it across the table to me and waited. I read the term sheet twice. Then I set it down and looked at my son, who was watching me with the particular expression he had worn since childhood when he wanted something not quite nervous, not quite confident, balanced somewhere between the two. I had built enough structures in my career to know that balance is not the same as stability. I told him I would think about it. He called me the next morning. I told him I needed a week. He called me 3 more times that week. On the 7th day, I called Patricia Chen, who had handled my legal work for 11 years at that point, and I told her I wanted a loan agreement drafted that was airtight, not a promissory note, not a handshake arrangement, but a formal secured loan with a lien on Marcus's ownership interest in the project, a fixed repayment schedule, and a personal guarantee. Patricia had been a real estate attorney for 26 years. She said, "David, I've written 100 of these. Half of them end up in my litigation file. Are you sure?" I told her I was sure, but I wanted the document to be bulletproof regardless. She said she would have a draft to me by Friday. I signed the agreement on a Tuesday in October, 5 years ago. Marcus signed it the same day. The loan was $800,000, secured against his interest in the Burnside Commons project, repayable in full by the 18th month with simple interest at 4% annually. He shook my hand at the table in Patricia's office on Southwest Morrison. He said, "Dad, this changes everything." I told him I hoped it did. For the first 8 months, I believed most of what Marcus told me. He sent project updates not every week, but regularly enough. He called on Sundays, sometimes for 20 minutes, sometimes longer. He brought me to the site twice during the foundation phase, and I walked it with him the way I had walked every project of my own career, checking the rebar spacing, looking at the pour, asking the site foreman questions that Marcus couldn't always answer, but that the foreman, a man named Phil Reyes, who had been in concrete work for 22 years, answered correctly and without hesitation. Phil Reyes knew what he was doing. I was less certain about Marcus. The first repayment was due at month 6. It was a partial payment, $30,000 against the interest accrued. It did not arrive. I called Marcus on the due date. He said there had been a delay in the construction draw, that the lender was processing paperwork, that it would be resolved within 10 days. I wrote the date on a notepad I kept in the drawer of my desk at home. 10 days passed. I called again. He said another week. I wrote that down too. The payment arrived 6 weeks late, and it was short by $4,000. Marcus said it was a wire transfer rounding issue. I did not press the point, but I called Patricia that afternoon and told her to flag the file. He married Jennifer that spring, in April, at a venue in the Pearl District that cost more than the partial payment he had missed. I attended the wedding. Jennifer was 30 years old, had a background in marketing, and had been working with Marcus's company for about a year in some capacity that was never precisely defined to me. She was pleasant at the wedding in the way that people are pleasant when they are still deciding what they think of you. She called me David from the first conversation, which I did not object to, and she asked questions about my career that sounded genuine but were spaced too evenly, the way questions sound when someone has prepared them in advance. After the wedding, the calls from Marcus became less frequent. The project updates stopped. When I reached out, he was always in a meeting, always traveling, always just about to call me back. The second scheduled repayment, $160,000 at month 12, did not arrive on the due date. When I called, Jennifer answered Marcus's phone. She said he was on site. She said he would call me that evening. He called me 4 days later. He said the project had hit a structural issue, a soil condition that required remediation, unexpected cost, not in the original budget. He said the lender had put the draw on hold while the engineering report was finalized. He said he needed more time on the repayment, and he said it in the tone of a man who has already decided that the answer will be yes. I asked him to send me the engineering report. He said he would. It never came. I called Gerald Cho, the former employer, again. Gerald had heard through the development community that the Burnside Commons project was in trouble, not because of soil conditions, but because Marcus had over-leveraged a second project in Beaverton and was using the construction draws from Burnside to cover shortfalls there. Gerald said he had no documentation, just what he had heard. I thanked him and hung up. Then I called Patricia and told her to pull the public records on both projects. What Patricia found over the following 2 weeks was a pattern that was not quite fraud, but was close enough to it that the distance did not comfort me. Marcus had drawn from the Burnside construction loan on a schedule that did not match the project's actual completion milestones. The draws had been certified by a project manager whose license had lapsed 18 months earlier, a man named Terrence Webb, who had been Marcus's college roommate and who was listed on the company's website as Director of Construction Management. The Beaverton project had a second lien on it from a private lender that had not been disclosed in any of the financial statements Marcus had shown me, and the personal guarantee he had signed on my loan agreement was secured against assets that, upon closer inspection, were held in Jennifer's name. I sat with that information for 3 days before I said anything to anyone. I had learned, in 34 years of engineering work, that the moment you react to a structural failure before you fully understand it is the moment you make the damage worse. You assess first. You act second. It was Jennifer who moved the situation into a different category entirely. She called me on a Thursday evening in March, about 2.5 years after the original loan, and she was direct in a way that Marcus had never been. She said that she and Marcus had been talking, and they felt that the loan arrangement had put an unfair strain on their relationship with me, that the formality of it, the contract, the lien, the interest had created a dynamic that felt transactional rather than familial. She said that what Marcus really needed, going forward, was a father who supported him unconditionally, and that the loan structure as written made that difficult. I let her finish. Then I asked her what she was proposing. She said they thought it would make sense to convert the loan to an equity contribution, meaning I would release the lien. Marcus would give me a 40% interest in the project instead of repayment, and we would start fresh with a cleaner arrangement. She said the project was going to be very successful and that 40% was generous. I said I would think about it. I called Patricia the next morning. She said, "If you sign that, you lose the security interest and you have no legal recourse for the original $800,000. I told her I knew. She said, "What are you thinking?" I told her I was thinking that Jennifer had just told me exactly what Marcus wanted and exactly what he was willing to do to get it. Patricia was quiet for a moment. Then she said, "All right, what do you want me to do?" I told her to start documenting everything from the beginning, every payment, every missed deadline, every phone call I could reconstruct, and to keep the file confidential. After that call, Marcus began the rewriting. It was gradual, the way these things always are. He started mentioning to mutual acquaintances, people I knew from the industry, from the neighborhood, from the church my wife and I had attended for 20 years before she died, that things between us were strained. He described it as a conflict over the business, but the framing shifted depending on who he was talking to. To some people, I had inserted myself into his company in a way that undermined his authority. To others, I had withheld support at a critical moment and forced him to scramble. To a contractor named Dale Whitmore, who called me in January to ask if everything was all right between Marcus and me. Marcus had apparently said that I had used the loan as leverage to control his decisions, and that he was trying to find a way to free himself from it. Dale Whitmore had known me for 18 years. He told Marcus he didn't believe that sounded like me. Marcus said that people weren't always who they appeared to be. I thanked Dale for telling me and wrote down the date and the substance of the conversation. Then I bought a small digital recorder, the kind that fits in a shirt pocket, and I began carrying it to every meeting and phone call that involved Marcus or anyone connected to his business. The recorder was in my pocket on the evening in February when Marcus called and said he needed to meet. He came to the house on Thurman Street, the house he had grown up in, the house where his mother had died 7 years earlier in the back bedroom, the house that had been in my name for 31 years. He sat at the same kitchen table where he had spread out those project documents 5 years before. He did not bring a folder this time. He said he wanted me to sign a document transferring 40% of my ownership interest in 3 properties, not just the Burnside project, but also the duplex on Gleason and the commercial lot on Nido Parkway to his company's holding entity. He said it was a restructuring, that it would simplify the legal arrangement, that it was the right move for both of us. He slid a document across the table. It was 12 pages, already tabbed for signature. I looked at the document. I did not pick it up. I asked him what happened to the $800,000. He said the project had been difficult, that there were factors outside his control, that he had done everything he could. I asked him about the Beaverton lien. He said that was a separate matter. I asked him about Terrence Webb's lapsed license. He stopped talking. Then he said, and the recorder was running in my shirt pocket, "Dad, if you don't sign over the property, I'm going to have to tell people the truth about what you did, about how you used that loan to control me, about how you made it impossible for me to operate independently. I'll have to be honest with everyone about what kind of father you actually were." I looked at my son for a long moment. He was 34 years old and sitting in the chair where his mother used to sit on Sunday mornings, and he was telling me that if I did not sign over property I had spent 31 years building, he would tell people I was a bad father. I said, "I need to think about it." He left 30 minutes later. I sat at the kitchen table for a while after he was gone. The recorder was still running. I reached into my pocket and turned it off. Then I called Patricia Chen. It was 9:17 in the evening. She answered on the second ring. I told her what had happened. She was quiet for 4 seconds. Then she said, "Tell me you were recording." I told her I was. She said, "David, don't sign anything. Don't respond to Marcus directly. I'm going to need you to bring me everything, the original loan agreement, every payment record, every email, and that recording by Thursday morning. And I need you to know that what he just did has a legal name." I asked her what the name was. She said, "Extortion." Over the following weeks, Patricia also discovered something I had not known. Marcus had sent me an email 3 months earlier, in November, that contained an attached document, a routine project status update. He had called it, asking me to confirm receipt by clicking a link. I had clicked the link. What I had not known was that the link contained an embedded signature authorization, and that my click had been logged by a third-party document platform as an electronic signature on a consent form that purported to initiate a title transfer process on the Nido Parkway property. The form had never been filed with the county, but it existed. Marcus had it. And Patricia, when she found the email chain and traced the document platform, said the word she used was forgery, and that she was going to need to involve a forensic document examiner before we proceeded. I had built structures for 34 years. I had read thousands of documents. I had signed my name to contracts in 4 states and 2 countries. I knew what my signature looked like, and I knew I had never signed that form, but I had clicked a link in an email from my son because I had no reason, at the time, to believe my son would do what he had done. I thought about that for a long time. I thought about the kitchen table and the heavy paper and the tabs in the folder and the handshake in Patricia's office on Southwest Morrison 5 years ago. I thought about the Sunday phone calls and the 2 site visits and Phil Reyes answering my questions correctly without hesitation. I thought about the wedding in April and Jennifer's prepared questions and the way she had called me David from the first conversation. I thought about the chair where my wife used to sit. Then I stopped thinking about it and called Patricia back to tell her to proceed. 6 months before the birthday dinner, I was walking a decommissioned warehouse site on the east side of the river. A former industrial property a developer had hired me to assess for structural viability. I had done that kind of work for 34 years, reading concrete, reading steel, reading the places where water had gotten in and time had done its work. I knew how to move through a building that was coming apart. I thought I knew every way a structure could surprise you. The beam was a W12F96 standard wide flange. It had been partially cut, not by time, but by an angle grinder, and someone had covered the cut with a panel, and the panel held until it didn't. It came down on my left side. I was turning when it hit. The site foreman, a man named Gil Navarro, found me on the floor 11 minutes later. 2 cracked ribs, a fractured clavicle, a torn labrum, 14 days in Providence Portland Medical Center, and then 2 weeks at home in a recliner I had owned for 11 years and never once found comfortable until I had no other option. Marcus called on the 3rd day I was in the hospital. He asked how I was feeling. I told him I was managing. He said he was glad. And then he said he needed to talk about the Morrison District project, the mixed-use development he had been building for the past 18 months, the one he had brought me into as a silent partner, and then proceeded to use my name and credit profile in ways I had not fully understood at the time. He said the investors were getting nervous. He said there were timelines. He said the deal needed to move. I told him I was in a hospital bed with a drainage tube in my shoulder. He said he understood that. But the investors didn't know about my situation, and it would be better if they didn't find out right now. And could I review the documents electronically? I told him we would talk when I was out. He called twice more before I was discharged. Both times I let it go to voicemail. Both messages were variations of the same thing: the project, the investors, the timeline, the opportunity. The word opportunity appeared in both messages. I noticed that. On the 11th day, while I was still in the recliner with my arm in the sling, Gerald Cho called. Not because I had reached out, I hadn't, not since the hospital, but because Gerald Cho was the kind of man who paid attention to what moved through the development community. And something had moved. He said he'd been looking more carefully at the Beaverton project, the one Marcus had been drawing from to cover Burnside. He said he'd found a second lien, not rumor this time, public record, filed 6 weeks earlier, and that the lender on that lien was a private equity group with a history of aggressive collection. He said, "David, whoever is advising your son needs to tell him this is about to become very visible." I thanked him and asked him to put it in writing an email, just the facts, what he found, and where. He said he would have it to me by end of day. It arrived at 4:17 that afternoon. I forwarded it to Patricia at 4:18. She called back within the hour and said, "This is the 3rd piece. We have enough to move." I told her to hold until I was out of the recliner. She said she would, but we both knew the file was complete. I was home for 4 days before the documents arrived. Marcus sent them by courier, not email. Courier, a thick envelope that arrived on a Tuesday morning while I was sitting in the recliner with my left arm in a sling and a cup of coffee I could not lift without pain. The courier was a young man who had me sign a receipt with my right hand. I thanked him and set the envelope on the side table and did not open it until the afternoon. The documents were a partial transfer of interest, 40% of my equity stake in the Morrison District LLC, to be assigned to a holding company I did not recognize. The holding company had been incorporated in Delaware 4 months earlier. I recognized none of the principals listed. The transfer was structured so that it would take effect upon my signature immediately, with no review period and no right of rescission. There was a tab on the signature page. The tab was red. I set the documents on the coffee table and looked at them for a while. Then I picked up my phone and called Marcus. He answered on the first ring, which told me he had been waiting. "Dad, the investors are waiting," he said. "We need this done now. If we miss this window, the whole Phase 2 financing falls through." I had been in the construction industry for 34 years. I had signed contracts worth more than $40 million over the course of my career. I had read thousands of pages of legal documents, some of them written specifically to obscure what they were actually transferring. I knew what this document was. I knew what the Delaware holding company was. I knew what the red tab was for. "No, Marcus," I said, "I'm not signing anything." There was a pause. Not long, maybe 3 seconds, but long enough that I could hear him recalibrating. "Dad, you don't understand the timeline." "I understand the document," I said. "The answer is no." Another pause. When he spoke again, his voice had changed. The professional register was gone. "You've never supported me," he said. "Not once, not in any way that actually mattered." I didn't answer. "I built this from nothing," he said. "You know what you contributed, a name on a piece of paper. That's all you've ever been willing to give me. A name." I still didn't answer. I had learned, over many years, that silence in a conversation functions the way load-bearing walls function in a building. It holds the structure up while everything around it continues to move. Marcus spoke for another 40 seconds, I counted, because counting is a habit I developed on job sites and never lost. And in those 40 seconds, he said 3 things that I noted carefully and did not respond to. Then he hung up. I sat in the recliner for a while. The coffee was cold. I drank it anyway. Outside the window, the neighbor's oak tree, a tree that had been there longer than my house, was losing its leaves in the November wind, and I watched them go for a few minutes before I picked up the phone and dialed Patricia Chen. Patricia had been my attorney for 11 years. We had met at a professional conference in Seattle, at a panel on construction liability law, and she had asked 2 questions during the Q&A that told me she was the kind of lawyer who read documents the way I read buildings, looking for the places where the load was being transferred in ways the surface didn't show. She had a practice on Southwest Morrison, the same street where Marcus's development now stood, which I had always thought was either a coincidence or a kind of symmetry, and she had been handling my estate planning and contract review since the year my wife died. She picked up after 2 rings. "I just declined to sign a document Marcus sent by courier," I said. "A 40% equity transfer to a Delaware holding company I've never heard of. He called the principals investors. He didn't name them." "When was the LLC formed?" 4 months ago. I heard her writing. Patricia always wrote by hand during phone calls. She had told me once that typing during a call made her feel like she was somewhere else. "What was his reaction when you said no?" "He told me I'd never supported him. Then he hung up." "Has he done anything like this before? Sent documents for signature without prior discussion?" "3 times in the past 2 years," I said. "Smaller amounts. I signed 2 of them. I shouldn't have." She was quiet for a moment. "David," she said, "I think he's about to do something drastic. What do you think?" "I know he is," I said. "I need to document everything. Whatever he's been doing with my name and my credit, I need all of it on record before he moves again." There was a pause on her end. When she spoke, her voice was level and careful, the same tone she used when she was about to tell me something she had been waiting to tell me for a while. "I've been waiting for you to say that," she said. We talked for 40 minutes. By the end of the call, she had a list of every document I could recall signing, every phone call in which Marcus had referenced my assets or my name, and the full text of the 2 voicemail messages he had left while I was hospitalized, which I played for her through the phone. She asked me to forward her the courier documents without opening the envelope again. She wanted the chain of custody intact. I put them back in the envelope, sealed it with tape, and left them on the side table for her assistant to collect the following morning. 4 days later, Marcus received a letter on Patricia's firm letterhead. I did not see his face when he read it, but I know what the letter said, because I had approved every sentence before it went out. It stated, in the formal language that Patricia favored for correspondence of this kind, that David Calloway, that is me, was hereby placing all parties on notice that no signature, endorsement, credit authorization, or use of his name in connection with any real estate transaction, financing agreement, or business formation document would be considered valid unless accompanied by written consent obtained through his attorney of record. It further stated that any document purporting to bear his signature, executed after the date of hospitalization, would be subject to forensic review. It named the Morrison District LLC specifically. It named the Delaware Holding Company by its registered name, which Patricia had found in 20 minutes of public records research. It was 3 pages long, and it was sent by certified mail. Return receipt requested. Marcus called me the same afternoon the letter arrived. I did not answer. He called again the following morning. I did not answer that time either. He did not call a 3rd time. What I learned later from a source I will account for in full when the time comes was that Marcus had shown the letter to Jennifer that evening, and that Jennifer had read it twice and then set it on the kitchen counter and said that they needed to get ahead of this. That was the word she used, ahead, as if there were a race in progress and they had only just noticed they were in it. Jennifer was not wrong that they were in a race. She was wrong about who had started it, and she was wrong about how far behind they already were. What Marcus had understood, reading Patricia's letter, was that his father was no longer operating alone. What he had not understood, and would not understand until much later, in a room he had not anticipated being in, was that his father had not been operating alone for quite some time. The letter was not the beginning of my preparation. It was the first thing I had allowed him to see. He was afraid of it. I know that because of what he did next, and because of what Jennifer told him to do, and because of the particular kind of decision that people make when they are afraid and in a hurry and believe that a loud public action will substitute for a strong legal position. It will not. I knew that. I had known it for 34 years. From the first time I watched a contractor try to bluster his way through a structural failure with a room full of engineers. Bluster is not load-bearing. It never has been. I put the phone down and looked at the recliner, and at the window, and at the oak tree outside that had been there longer than my house. Then I reached for my coffee, my right hand, carefully, and drank what was left of it while it was still warm. The invitation to my own birthday party went out 6 weeks before the date. I had written the guest list myself, 70 names, some of them going back to my years at the firm, some from the neighborhood, a few from the university where I'd taught a structural engineering seminar for 11 years. Patricia had asked me, when I gave her the list, whether I was certain I wanted Marcus included. I told her yes. She looked at the list for a moment, then looked at me, and said nothing more about it. The Riverside Hotel ballroom held 200. For 70 people, it felt generous, which was the point-round tables with white linen, the kind of room where sound carried differently than in a restaurant, where a voice raised above the ambient noise would reach every corner without effort. I had been in that room before for a Structural Engineering Awards dinner in 2009. I remembered the acoustics. They were excellent. Patricia had called me on a Wednesday, 10 days before the party. She said that Marcus had spoken to his attorney, a man named Garrett Cole, who had a small practice in the Pearl District and who specialized, according to his website, in family business transitions. Patricia knew Cole by reputation. She said he was competent enough, but that he had a habit of letting clients make decisions that served their emotional needs rather than their legal ones. She said that Marcus was planning something public. She did not know exactly what. She said, "David, I want you to be prepared for the possibility that he uses the party as a platform." I told her I understood. She said, "Are you sure you want to go through with it?" I told her that I was. I told her that if Marcus was going to do what I believed he was going to do, I wanted it done in front of witnesses, 70 of them, specifically. The party was a Friday evening. I arrived at 6:30, which gave me time to speak to the hotel's event coordinator, a young woman named Alicia, who had managed the room for 4 years and who knew how the microphone system worked. I shook hands with people I hadn't seen in months. My neighbor, Robert Huang, not the judge, a different Robert, a man I'd known for 40 years since we were both junior engineers at the same firm, had driven in from Lake Oswego. He sat at my table, on my left, and ordered the salmon. Marcus arrived at 7:15 with Jennifer. He was wearing a charcoal suit I hadn't seen before. Jennifer wore something dark blue. They sat at a table near the back, not at mine. I noticed that Marcus had a folded sheet of paper in his breast pocket. He touched it twice before the salads arrived. The dinner moved the way dinners move courses. Conversation. The low hum of a room where people are comfortable and well-fed. A few people gave short toasts. My former colleague Stan Whitfield said something about the Burnside Bridge project from 2001 that made the engineers at his table laugh. My cousin Dorothy said something kind about my wife, and I thanked her. The room was warm. The wine was a Willamette Valley Pinot Noir that I'd selected myself, and it was good. At 8:27, I know because I glanced at my watch when I heard Marcus's chair scrape back. He stood up. He did not ask for the microphone. He didn't need it. His voice carried. He said, "David, not Dad. My name." The room began to quiet, the way rooms do when someone stands unexpectedly. He said, "I want to say something tonight while everyone is here." I set down my fork. I folded my hands on the table. I looked at him. He spoke for approximately 4 minutes. I counted the sentences. There were 19. He said that I had never supported him, that I had been controlling his entire life, that I had withheld money that was rightfully his, that I had treated him like an employee rather than a son. He said the word toxic twice. He said that he was done, that I was not his family anymore, that I had never been a real father. The last sentence was, "I'm done. You're not family anymore, and I want everyone in this room to know it." He had rehearsed it. I could hear the rehearsal in the rhythm of it, the pauses in the right places, the voice dropping at the end for effect. Jennifer had written it for him, or most of it. The word toxic was hers. Marcus didn't use words like that on his own. The room went silent. Then, at the table near the window, someone laughed, a short, uncertain sound, the kind that happens when a person cannot determine whether what they are witnessing is a joke or not. Then silence again. I did not stand up. I did not raise my voice. I picked up my fork and took a bite of the chocolate torte that had been placed in front of me while Marcus was speaking. It was good. Dark chocolate, not too sweet, with a raspberry reduction that the kitchen had done correctly. Marcus was still standing. He had expected something. A reaction. A defense. Tears. Possibly he had always believed that pressure produced tears, because it had, a few times, when he was younger and I was less certain of what I was doing. Or anger. Anger would have served him. Too, it would have made me look unstable, made his 19 sentences seem proportionate. He got neither. He got a man eating dessert. Robert, on my left, leaned toward me. He said now quietly, "David, are you okay?" I said, "I'm fine. This is exactly what I expected." He looked at me for a moment. Robert had known me for 40 years. He understood, I think, that I was not performing calm. He nodded once and picked up his own fork. Marcus sat down. Jennifer put her hand on his arm. I did not look at them again for the remainder of the evening. Several people came to speak to me before the night ended. Stan Whitfield, Dorothy, a former client named Ed Brannigan who had flown in from Seattle. None of them mentioned what Marcus had said. They were being polite. I appreciated that. I left the Riverside at 10:15. The valet brought my car. I drove the 12 blocks to my house and sat in the driveway for a moment with the engine off, listening to the tick of the cooling engine. Then I took out my phone and called Patricia. She answered on the second ring. She said, "How did it go?" I said, "He did it, in front of 70 people. We're ready for the next phase." There was a brief pause. Then Patricia said, "I'll have everything prepared by Monday morning." I said goodnight, went inside, and put the kettle on. The oak tree outside the kitchen window was dark against the sky. I had planted that tree the year Marcus was born. It was taller than the house now. I drank my tea standing at the counter, and when it was finished, I rinsed the cup and went to bed. The letter arrived at Marcus's office at 8:47 on Monday morning. Patricia had sent it by certified mail and by process server simultaneously 2 copies, 2 signatures required. No room for Marcus to claim he hadn't received it. I knew the timing because Patricia called me at 9:15 to confirm delivery. She said the process server reported that Marcus had read the first paragraph, set the letter down on his desk, and then picked it up and read it again. I didn't ask how the process server knew that. Patricia had been doing this work for 30 years. She knew how to place people. The letter outlined 3 specific allegations: extortion, fraudulent signature on a federal properties transfer document, and misappropriation of funds totaling $800,000 over a period of 6 years. It required Marcus to appear at the Multnomah County Courthouse on Thursday morning at 9 o'clock. It was not a request. The call started at 9:23 that same Monday morning. I was at my kitchen table with a second cup of coffee and the crossword from Sunday's Oregonian. I'd left it unfinished when my phone began to ring. I looked at the screen. Marcus. I set the phone face down on the table and went back to the crossword. 14 across. 7 letters. A structure built to last. I wrote in the answer and moved on. By Tuesday evening, he had called 49 times. I know the exact number because my phone logged every attempt. He left 11 voicemails. I listened to all of them. Once, with a notepad beside me. The first 3 were versions of the same sentence. Dad, this is a misunderstanding. Call me back. The 4th was longer. He said he was sorry. He said he'd been under pressure with the East Side development, that Jennifer had pushed him, that he hadn't meant for things to go this far. The 5th voicemail, left at 2:14 in the morning, was quieter. He said, Dad, please, I'm sorry, we can work this out. His voice had the particular quality of a man who has not slept and has finally understood that the situation is real. I did not call back. I sent one text message at 6 Wednesday morning before I left for my walk along the Willamette. It said, see you in court. He did not respond to that message. I put the phone in my jacket pocket and walked the river path for 40 minutes, watching the light come up over the water. The Multnomah County Courthouse on Thursday morning smelled the way courthouses always smell: floor wax and recycled air, and something older underneath, something that has absorbed decades of decisions. I arrived 20 minutes early and sat in the hallway outside courtroom 4 with Patricia, who had a leather portfolio open on her knee and was reviewing the order of her exhibits with the focused calm of someone who has done this hundreds of times and finds it neither exciting nor frightening, only necessary. She had 6 categories of evidence. The forged signature documents, 3 pages, each bearing a version of my name that Marcus had practiced enough to be convincing at a glance, but not under examination. The loan record, 6 years of transfers, totaling $800,000, with no repayment schedule ever honored and no acknowledgement in writing after the first year. The property transfer filing that Marcus had initiated without my knowledge or consent, using the forged signature, which had been caught by a county clerk named Diane Marsh, who had been processing real estate documents in Portland for 19 years and recognized the inconsistency in the notarization date. And the recording. The recording was 11 minutes and 43 seconds long. Patricia had had it transcribed and authenticated. She handed me a copy of the transcript at 8:50, and I read the first page while we waited. I had heard the audio before I had been the one to make it. On a Tuesday afternoon 4 months ago, when Marcus had come to my house and we had sat at the kitchen table, I had offered him coffee. He had declined. He had told me that if I did not sign the property transfer documents voluntarily, he would go to my colleagues, my former business partners, and tell them that I had abandoned him and his mother during his childhood, that I had been absent for years while pursuing contracts overseas, that I had left them without support. He said he had documentation. He said people would believe him. He said it quietly, the way he said most things, with the particular confidence of someone who believes they are the only person in the room who has thought this through. He did not know about the recorder in my shirt pocket. I had placed it there before he arrived. I had learned, in 31 years of engineering work on sites where contracts were disputed and agreements were verbal and people's memories were conveniently selective, that the most important thing you can do before a difficult conversation is ensure that you will remember it accurately afterward. At 9:02, the bailiff opened the courtroom door. Robert Huang had been a circuit court judge for 14 years. Before that, he had been a civil litigator for 22 years. Before that, he had sat 2 rows ahead of me in Professor Kellerman's structural mechanics class at Oregon State in 1983, and he had borrowed my notes before the midterm because he had missed a week with pneumonia. We had not been close friends, more the kind of acquaintance that a university produces. 2 people who share a context and a mutual respect without ever becoming essential to each other's lives. I had not spoken to him in 11 years when Patricia filed the case. I did not consider our history an advantage. Robert Huang was not the kind of man who would allow it to be. He entered the courtroom at 9:08 and settled into his chair with the unhurried manner of a man who has presided over enough proceedings to know that urgency is almost always counterproductive. He reviewed the case file for 2 minutes without speaking. Then he looked up and said, "Ms., Chen, you may proceed. Marcus was seated at the respondent's table with his attorney, a man named Gerald Fitch, who had represented several mid-sized Portland developers and who had, Patricia told me, a reputation for aggressive procedural motions and a much weaker record at actual trial. Jennifer sat in the first row of the gallery, directly behind Marcus. She was wearing a gray blazer, and she had her hands folded in her lap, and she was very still. There were 6 other people in the gallery. 2 of Marcus's investors' men I recognized from photographs Patricia had shown me, a developer named Craig Whitfield and a commercial lender named Stephen Park, and 4 others whose presence I noted but did not yet understand. Patricia presented the loan records first. She walked Judge Huang through the transfer history methodically, year by year, amount by amount. Gerald Fitch objected twice on relevance grounds. Both objections were overruled without elaboration. Then Patricia presented the forged signature documents, and she called Diane Marsh, the county clerk, who testified for 9 minutes about the notarization discrepancy and the process by which she had flagged the filing. Diane Marsh was a compact woman with reading glasses on a chain around her neck, and she answered every question in the flat. Precise register of someone who deals in facts professionally and finds speculation wasteful. Marcus's attorney cross-examined her for 4 minutes. He did not make progress. Then Patricia said, "Your Honor, I'd like to play Exhibit 7. She pressed play on the laptop connected to the courtroom's audio system. My voice came through the speakers first, offering coffee, then Marcus's voice, declining. Then, after approximately 90 seconds of conversation about the East Side Development Project and its financing gaps, the moment Patricia had marked in the transcript, "If you don't sign over the property, I'll tell everyone you abandoned me. I have documentation. People will believe me. You know they will." The courtroom was very quiet. I turned in my chair and looked at Marcus directly. He was looking at the table. I waited until he looked up. When he did, I said, quietly enough that only the front of the room could hear, "You said it yourself. Marcus, 11 minutes and 43 seconds. He opened his mouth. Nothing came out. Marcus's attorney was on his feet immediately. "Your Honor, my client was under significant emotional distress at the time of this conversation. The statement was not a threat. It was the expression of genuine grievance from a son who felt abandoned by his father." Judge Huang looked at Gerald Fitch for a moment. Then he looked at Marcus. Then he pressed his fingertips together and said, "Mr. Calloway, your attorney has characterized your words as emotional expression. I've now heard the recording twice. The tone is not emotional, it is transactional. There is a condition and a consequence. That is the structure of extortion, not grief." He paused. "Do you understand the distinction I'm drawing?" Marcus said, "That's not what I meant." Judge Huang said, "What you meant and what you said are 2 different questions, and this court is concerned with the second one." He picked up the forged signature documents and studied the 3rd page for a moment. "Ms. Chen, these documents were filed with the county recorder's office." "They were, Your Honor. The filing was flagged before it was processed, but the submission itself constitutes an attempt to execute a fraudulent transfer using a forged signature on a federal property document." Judge Huang set the papers down. He looked at Marcus with the expression of a man who has heard many explanations and is not anticipating a new one. He said, "Mr. Calloway, you've committed extortion and fraud. This is not a civil matter. This is criminal." He turned to Patricia. "Ms. Chen, has a referral been made to the appropriate federal authority?" "It has, Your Honor. The FBI's Financial Crimes Unit received the documentation last Friday." Marcus's face, when I allowed myself to look at it, had the color of old concrete. Jennifer, in the first row, had unfolded her hands and was pressing them flat against her thighs. She was staring at a point somewhere above the judge's bench. Judge Huang issued his orders in the measured cadence of a man reading from a list he had already composed in his mind. Marcus was to repay $800,000 to me within 90 days, with interest calculated from the date of the last transfer. Marcus was prohibited, by court injunction, from using my name, my signature, my property, or any representation of my authorization in any transaction, legal or commercial. The FBI referral would proceed independently of the civil judgment. He asked both attorneys if they had anything to add. Patricia said no. Gerald Fitch said no. The gavel came down at 10:41. Craig Whitfield left the gallery first. He did not look at Marcus. He was on his phone before he reached the door, and I heard him say, quietly but not quietly enough, "Get Henderson on the line. We're pulling out. We don't do business with people who commit fraud." The door swung shut behind him. Stephen Park followed 30 seconds later without speaking to anyone. The room thinned quickly after that. Patricia gathered her documents with the efficient movements of someone who has won enough to know that winning does not require ceremony. I sat at the plaintiff's table and did not move while the room emptied around me. Marcus came to me when there were 4 people left in the room: Patricia, Gerald Fitch packing his briefcase at the far table, the bailiff near the door, and Jennifer, who had not moved from her seat in the first row. He stood at the edge of the plaintiff's table. He looked smaller than he had at the birthday dinner, not physically, but in some other way that I noticed without naming. He said, "Dad, please. I can explain. I was desperate. The East Side deal was collapsing, and I didn't know what else to do. Please help me." I stood up. I looked at him for a moment, at his face, which I had known since the morning he was born, which I had watched change through 34 years of mornings. Then I picked up my copy of the court order from the table. I said, "I already did help you for 34 years. I walked to the door. The bailiff held it open. I did not look back. The hallway outside courtroom 4 was empty except for a young woman with a stroller waiting for the elevator. The floor wax smell was stronger out here. I walked to the stairwell, took the stairs down to the ground floor, and pushed through the heavy glass door into the October air. Portland in October has a particular quality of light gray, but not dark. The kind of light that makes everything look exactly as it is, without flattery or shadow. I stood on the courthouse steps for a moment, then walked to where I had parked, 3 blocks east on Morrison. My phone had 2 messages, one from Patricia, sent while I was still in the stairwell, all documents filed, federal referral confirmed, call me when you're ready. One from a number I didn't recognize, which turned out to be Craig Whitfield's assistant, requesting a brief call at my convenience regarding a separate development consultation. Apparently, Whitfield had looked me up before he left the courthouse. I put the phone in my pocket and kept walking. The car was where I had left it. I unlocked it, sat down, and closed the door. The street outside was ordinary, a delivery truck double parked, 2 women talking on the corner, a cyclist waiting at the light, the city conducting its business, indifferent to what had just happened in courtroom 4. I started the engine and pulled out into traffic, heading west toward the river. The investors moved first. Craig Whitfield's email went out at 11:14 the same morning. I know the time because Patricia forwarded it to me with a note that said, "Only first domino." The email went to Marcus's project manager and was copied to his construction lender and to the 3 remaining equity partners. It stated that the partnership was being dissolved effective immediately pending a review of fiduciary conduct. It used the word fraud twice. It did not use the word allegedly. Stephen Park filed a parallel notice 40 minutes later. The other 2 investors followed by end of business. $2 million in committed capital, withdrawn in a single afternoon. The East Side Commons project, the one Marcus had been describing to everyone as his signature development for 3 years, was finished before the courthouse parking garage had emptied. I learned this from Patricia 2 days after the hearing. She read me the relevant language over the phone, and I listened without interrupting. When she finished, she said the other 3 investors had filed similar notices within 48 hours of the first. The East Side Commons project, the one Marcus had been positioning as his signature development, the one he'd used to justify every conversation about my assets over the past 3 years, was finished. $2 million in committed capital, gone. The investors weren't just walking away from the project. They were demanding restitution from Marcus personally for misrepresentation. Patricia said the civil exposure alone would take years to resolve. I thanked her and hung up. I was standing in my kitchen at the time, and I stayed there a while, looking at the window above the sink. Outside, the maple in the courtyard had started turning. It did that early some years, depending on the summer. This had been a dry one. The FBI inquiry came through the following week. A federal agent named Castillo Patricia said he had been in financial crimes for 9 years, left a message with her office regarding the forged signature on the amended property transfer, the one Marcus had submitted to a federally regulated lender. Castillo's message was brief and specific. He wanted the original loan agreement, the forged document, and the recording. Patricia had copies of all three already organized by exhibit number. She sent them by secure courier the same afternoon. Forging documentation in a transaction involving federal financing wasn't a civil matter. And Castillo's tone, Patricia said, was not the tone of a man conducting a preliminary inquiry. It was the tone of a man who had already read the file. Patricia told me I would likely be called as a witness. I told her I would cooperate fully. She said she knew. She also said, before she hung up, that Marcus's attorney, Gerald Fitch, had called her office that morning asking whether there was any path to a negotiated resolution before the federal process advanced. Patricia had told him there was not. The bank called Marcus on a Thursday. I know this because the branch manager, a man named Gerald Okafor, who had handled my accounts for 11 years, mentioned it when I came in to close the final transfer paperwork. He didn't say much, just that a notice of acceleration had gone out on the $800,000 line and that the bank's legal team was now involved. He handed me my documents, and I signed where Patricia had marked. Gerald said, "I hope things settle down for you, Mr. Harmon." I told him I thought they would. Jennifer left before the end of the month. I heard this from no one directly. I simply noticed, when Marcus began calling again, that the calls came only from his number and never from hers. Later, through Patricia, I learned that Jennifer had filed for divorce within 3 weeks of the hearing. She cited fraud as grounds specifically that Marcus had concealed the extent of his legal exposure during their marriage and had used jointly held assets as collateral without her knowledge or consent. She had retained a family law attorney with a strong record in fault-based claims and was seeking a settlement that included the equity in their Pearl District condo and a portion of whatever Marcus recovered from the probation restitution schedule. Patricia said Jennifer's attorney had contacted her office once, early in the process, to confirm the timeline of the original loan. Patricia had confirmed it. I didn't have a reaction to any of this. Particularly, Jennifer had made her own calculations throughout, and now she was making different ones. I had understood that about her from the first conversation when she asked questions that were spaced too evenly and called me David before she had any reason to. The calls started on a Tuesday, 49 of them over 11 days, which Patricia confirmed when she pulled the phone records at my request. I didn't answer any of them. Some had voicemails. I listened to the first 3. The first was formal, an apology for the hearing, a request to talk. The second was shorter and less composed. The third, Marcus's voice was different in a way I recognized from when he was very young, from the years before he learned to perform confidence. I listened to all 3 and then deleted them without saving. I did not listen to the remaining voicemails. There was nothing in them that would change the documents already filed or the testimony already given. The call at 2 a.m. came on a Friday, 2 weeks after the hearing. I was awake. I had been sleeping poorly since the move, not from distress, but from the ordinary adjustment of a new space, new sounds, the particular silence of a different building. I was sitting by the window when the phone lit up, his name on the screen. I let it ring 4 times, then picked up. He was crying, not performing, actually crying, the kind that breaks the voice into pieces and doesn't reassemble cleanly between sentences. He said he was sorry. He said he had made a terrible mistake. He said he was losing everything and didn't know what to do and that he needed my help. He said "Dad" several times, the way you say a word when you've run out of other words. I listened to all of it. I didn't move from the chair. Outside, the street was empty, and the only light was from a parking structure across the way, its amber glow steady and indifferent. When he stopped talking, I said, "You had a choice. Marcus, you chose this." Then I ended the call. He called back twice within the minute. I turned the phone face down on the table and did not look at it again until morning. I had moved into the new apartment 10 days after the hearing, a 2-bedroom on the 14th floor of a building on the west side, with a view of the river and, on clear days, the mountain. I paid the deposit and first month from my own account, the one Marcus had never known existed, the one I had maintained separately for reasons I hadn't fully articulated to myself at the time, but that now seemed obvious in retrospect. The apartment was smaller than the house and quieter. I bought a coffee table and 2 chairs and a lamp I liked. I left the rest for later. 6 months after the hearing, Marcus entered a plea agreement, 2 years probation, restitution of $800,000 to me, and a civil judgment requiring repayment of $2 million to the investors to be structured over time, but legally binding and enforceable. He would not practice as a licensed developer in Oregon for 5 years. The federal charge carried a permanent record. Patricia called to tell me when the agreement was finalized. I was at my drafting table, working through some consulting drawings for a small firm downtown that had reached out after Craig Whitfield mentioned my name. I thanked her and went back to work. The $800,000 arrived in installments, the first of which cleared 4 months into the probation period. I had already spoken with a nonprofit organization called Harbor House. They provided financial counseling and legal assistance to families who had been exploited by people they trusted, often adult children, often over years. I had reviewed their financials and their governance structure before I made any decision. When the first installment cleared, I transferred it in full to their operating fund. I did the same with each subsequent installment. I did not tell Marcus. It was not information he needed, and it was not a gesture I made for his awareness. I made it because the money had come from a particular kind of damage, and I wanted it to go somewhere that understood that damage precisely. About a year after the hearing, I was sitting at a corner table at a cafe near the river, a place I'd started going on Saturday mornings for the coffee and the light, when Robert Alderman came in. Robert had been my neighbor for 22 years. And before that, we had known each other from the industry, back when we were both working on commercial projects in the early 90s. He spotted me and came over without being asked, which was typical of Robert. He sat down and ordered without looking at the menu, which was also typical. He said he'd heard the case had resolved. I said it had. He looked at me for a moment, then said, "You did the right thing." I was there in that courtroom. I saw his face when Patricia laid it out. He finally understood what it means to be held accountable. I turned my coffee cup once in my hands. I said, "He had to learn." Robert nodded and didn't push further, which was why we had been friends for 40 years. People asked, occasionally, whether I missed my son. Not often, and not the people who knew the full story, but sometimes a colleague, someone I'd just met, making ordinary conversation. I had thought about what to say before anyone asked, because that was how I had always worked. You think through the answer before the question arrives. What I said was I had a son. He made his choice. That was accurate. It was also complete. I didn't feel the need to add anything to it, and I didn't. The maple in the new courtyard was younger than the one at the old house, and it hadn't turned yet. I figured it would, given time. I set my coffee cup down on the table and looked out of the window. The river was moving the way it always moved in October, gray and steady, indifferent to the particular weight of any given morning. I watched it for a while. Then I picked up the phone, turned it face down, and went back to the drawings.